Procedural is what I always wanted. Could never have too many things. Well, you quit kicking me under the table. I'm trying, will somebody make us shut up about it? Can we settle down, please?
Shalom, this is your Ark. Yah is magnified, coming back with another informative video. I titled this video, Motion to Stay and 20 Days to Consent. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All of my videos are for informational and educational purposes only. They're all facts and all truth, nothing more, nothing less. So with that being said, let's get to it. Okay, so now as you all know, I've been keeping an eye on this guy who's frauding people on YouTube who go by the name of Wasil Bay. You know, I already showed y'all one of his client cases who went in the federal court and lost in the district court. But not only that, that same client also lost in the appeals court. I'm going to show you all that, but not today. Today, I'm just going to continue to update y'all on his client Kayo's case, which is his recent case in federal court. Okay, so now as you can see, this is a motion to stay. But before we cover this motion to stay, I want y'all to see the date that this motion to stay was filed. This motion to stay was filed on August the 3rd, 2018, okay? This month, this year, okay? So this case is going on as we speak. So since the guy claimed you can go in the federal court and win, well, okay, so this is the perfect case to show us that his client Kayo will win in federal court. If his client Kayo do not win in federal court, then again, the guy don't know what he's doing and he don't know what he's talking about. So what I'm basically doing is making these guys put up or shut up. You know, they saying you can go in this federal courts and do this and do that. We haven't seen proof of it yet. So since they can't show us proof that it works, I'm just here to show y'all proof that it don't work. Okay? The proof is in the pudding. Make your decisions about who is showing the proof and who's showing the facts and who's keeping things 100 with you all. Okay, like I said, I could have came on YouTube and told you all these same lies and joined the good old boy squad. No, that ain't me. You know, I'm going against the grain because I know the truth and the truth made me free, and I'm trying to make this same truth make you all free. Okay, so now with that being said, let's go over Wasil Bay and the Sham Froster's client's case. As you all can see, this was done in the United States District Court for the Southern District of Texas, the Houston Division. As you can see, that's Julian S. Kayo again, the same plaintiff known as Kayo. He still versus the same people, the Family Law Center, Texas Health and Human Service Commission, Marquisha Lee, Serva Loom, and Bridget Natalie, defendants. Let's pick it up at the top. Defendant, Texas Health and Human Services Commission, motion to stay scheduling conference, joint case management plan, and discovery of interested parties. But not only did they file their motion to stay, so did Sarah Loom and Bridget Natalie. But I'm not going to go over it because it's basically the same thing. They both said the exact same thing and filed into the court. So now we're going to find out what is the outcome of this motion. And, you know, I'm going to bring y'all up to date to this very day, so you all can have understanding of what's going on. Like I said, don't take my word for it. Go back and rebut me. Prove me wrong. They want to talk about everybody's case on YouTube except for their clients' cases that's getting their butts kicked in these courts, man. They're not talking about their client cases, though, because they know, hey, it's looking bad for them. But let's continue. It says, to the Honorable Judge, Sim Lake. Defendant, Texas Health and Human Services Commission, defendant, or HHSC, files this motion to stay scheduling conference, joint case management plan, and discovery interested parties ordered by this court, document number 2, and respectfully request the court to stay all proceedings until HHSC Rule 12B1 and 12B6 motion to dismiss are ruled upon. Okay, so did y'all just see what happened here? Basically, what just have taken place is HHSC, which is the Health and Human Services Commission, asked the court to stay any further proceedings until the court rules on the 12B1 and 12B6 motion to dismiss. Okay, so now We're going to read over this whole order, but then we're going to see if the court grants this order to vacate everything until it makes the ruling on the 12B1 and 12B6 motion to dismiss. Okay? But let's pick this up at number 1. 1. Introductions and factual backgrounds. On April the 24th, 2018, plaintiff Julian S. Cayo, plaintiff or Cayo, filed a complaint asserting violations of his U.S. and state constitutional rights by HHSC and other co-defendants. Document 1-1. On May 14, 2018, HHSC filed its motion to dismiss Cayo's lawsuit pursuant to Federal Rules of Civil Procedures 12B1 for lack of subject matter jurisdiction and 12B6 for failure to state a claim upon which relief can be granted. Document number 3. On June 5, 2018, Cayo filed an objection to HHSC's motion to dismiss. Document 6. On June 13, 2018, HHSC filed its reply to Cayo's objection to its motion to dismiss. Document number 7. On July 11, 2018, Cayo filed his second objection to HHSC's motion to dismiss, which included a section entitled Rebuttal of Sarah Loon, Bridget Natalie, Marquisha Lee, and Texas Health and Human Services. Let's continue. That's a document number 10. On July 27, 2018, HHSC filed its reply to Cayo's second objection, document number 11. In his latest response to HHSC's motion to dismiss, Cayo still fails to show he has subject matter jurisdiction or states a claim upon which relief can be granted. Therefore, his cause of actions must be dismissed. Let's continue. So now we see exactly where the HHSC is going with. They're going directly to that 12B1 and 12B6, the same two Federal Rules of Civil Procedure codes that they always go with, and it will be granted. Don't take my word for it. We'll see by the end of this case. Okay, but let's continue. It says this court entered an order for conference and disclosure of interested parties to facilitate entry of a scheduling order under Federal Rules under Federal Rules of Civil Procedures 16B, and directed the parties to begin the pretrial discovery process of Federal Rules of Civil Procedures 26, which is due on August the 17th, 2018, document number 2. HHSC now asks this court to issue a stay to the scheduling conference, joint case management plan, and disclosure of the interested parties, which would occur pursuant to Federal Rules of Civil Procedures 16 and 26, until the threshold matters raised in its motion to dismiss Cayo's original complaint are ruled upon by this court. So again, they asking the federal court to stay all rulings, meaning move no further in any trial action or any actions at all dealing with this matter until they make a rule on the motion to dismiss. Okay? And anybody that's filing a motion to dismiss in the court, you can actually do the same thing. Pause all movements, make everything motion to stay until they make a decision on your motion to stay, like what they're doing to Wasil Bay client. They stopped all movement in his case until the judge make a ruling on that 12B1 and 12B6, okay, or for their motion to dismiss. But let's continue. Number 2, motion to stay. Pursuant to Federal Rules of Civil Procedures 26C, HHSC requests that this court vacate the previous order. So now, Health and Human Services request that this court vacates the previous order. What was the previous order? The previous order was to have the hearings or the pre-trial scheduling conferences and everything else. They was going to have the scheduling conference, the joint case management plan, and the disclosure of interested parties. Okay, so that's what they're asking them to vacate. So it says, number 2, motion to stay. Pursuant to Federal Rules of Civil Procedures 26C, HHSC requests that this court vacate the previous order, document number 2, and stay all discoveries in this lawsuit pending the resolution of the threshold issues of immunity and jurisdiction addressed in HHSC's motion to dismiss. So again, HHSC is not letting them move no further until they make a ruling on that 12B1 and 12B6 motion to dismiss that they put into the court. But let's continue. The law does not allow HHSC or any state agency, okay, so Clearly letting you know that Health and Human Service Commission is a state agency, which also letting you know that the Child Support Agency is a state agency. But let's continue. It's not a franchise. The word franchise is nowhere near mentioned on any of those documents. It's nowhere near mentioned in what's that joint called that he always going to, that Osiris always going to, uh his favorite Title 4D book. It's not mentioning that at all. But let's continue. To be forced into the discovery process when a plaintiff cannot overcome 11th Amendment immunity to suit or establish the subject matter jurisdiction of this court. The defense of 11th Amendment immunity provides immunity from suit, not merely from liability. Case law to back that up. But let's continue. As such, the burden of enduring suit or even the discovery process is very high as a matter of law. Case law to back that up. The Supreme Court has expressly noted the importance of such protection of government time and witnesses in the context of immunity to suit. Case law to back that up. The basic thrust of the immunity doctrine is to free officials from the concerns of litigations, including avoidance of disruptive discovery. Let's continue. Stays of discovery pending review of immunity questions are proper. Another case law to back that up. Then they're talking about Petrus versus Bowen. That's right. That's case law. But let's continue, because I only said that case law because that's the case law that they're going to quote in this order. But let's continue. In this motion. But let's continue. Indeed, engaging in discovery on the merits is not necessary, nor is it proper, prior to a ruling on the 11th Amendment immunity. Case law to back that up. Then it says the very object and purpose of the 11th Amendment were to prevent the indignity of subjecting a state to the coercive process of judicial tribunals at the instance of private parties. Let's continue. In the previous case, in the Petrus case, what I just read to y'all, that's why I told y'all I was going. I quoted the Petrus case because I knew they was going to copy. I knew they was going to quote this case in this motion. So it says in the Petrus case, the plaintiff filed suits against defendant who responded with a motion to dismiss pursuant to Federal Rules Civil Procedures 12B1 and 12B6, and affirming the trial court decision to stay discovery until the motion to dismiss was ruled upon. The Fifth Circuit noted, nothing that Petrus could have learned through the discovery could have affected the resolution of the defendant's 12B6 motion. We hold that the district court properly deferred discovery while deciding whether the defendants were proper parties to the action. That's Petrus that they was quoting. That's the case law. Let's continue. The Fifth Circuit has clearly established that when immunity from suit is raised, unless a plaintiff pleading asserts facts which overcomes that immunity, the district court should rule on the motion to dismiss before any discoveries is allowed. Another case law to back that up. As you all can see, they're still trying to prove their claim, basically stating that, this court can no longer move forward until they make a ruling on that 12B1, 12B6, HHSC's motion to dismiss. So let's continue. It says the Supreme Court has emphasized the importance of quickly resolving 11th Amendment claims because the value to the states of their 11th Amendment immunity is for most part lost as litigation proceeds past motion practices. Case laws to back that up. HHSC has demonstrated to this court that it is immune from Cayo's suit. As such, HHSC asserts the right to avoid the burden of discovery. Cayo has not met any burden of proof to divest HHSC of immunity from suit. Further letting you know that anybody telling you all to keep going to these courts, man, like I said, they did not make a ruling on this 12B1 or 12B6 yet. But when they do, I'm going to put it up. But right now, I'm letting you all know, they telling y'all to go in these federal courts. Watch the outcome. And I'm going to tell y'all from the beginning, I told y'all so. But let's continue. In the event that the court does not stay the proceedings in this case on the basis of the reason, analysts of several additional factors favor staying the case. There is no prejudice to Cayo's case if the request stay is granted. With the Petrus case, Allowing Coyote to conduct discovery will not provide Coyote any response to the immunities of HHSC, nor will it invade the doctrine depriving the courts of subject matter jurisdiction, or cure Coyote's failure to plead legal, cognizable claims against HHSC. Conversely, the burden on HHSC of proceedings in this lawsuit is considerable. Let's continue. HHSC maintains that its immunity from Coyote's lawsuit, and it must be able to perform its duties to the public as a state agency. So HHSC is a what? State agency. Further letting you know that the child support agency is a state agency, not a federal. They're telling you this back to back to back in every lawsuit. Don't let nobody tell y'all that they are a franchise of the federal government. No, they are a state agency. Let's continue. Discovery in this case would be unduly burden HHSC by forcing it to endure needless discovery prior to the resolution of the threshold immunity issues that have been raised. If the court grants HHSC's motion to dismiss, the standard discovery will operate to the convenience of the court. The needless procedures involved with the conducting of contested discovery, such as motions for protections, and motions to squash dispositions, will provide an unnecessary inconvenience to the court. When considering a case such as this, the trial court must exercise its discretion in a way that protects the substance of the immunity to suit defense, and must exercise its discretion so that officials are not subject to unnecessary and burdensome discoveries for or trial proceedings. Case law to back that up. Then it says, because the standard of discovery and related proceedings is appropriate in this circumstance, discovery and related proceedings from HHSC should be stayed as discussed supra until such a time as this court rules on HHSC's 12B1 and 12B6 motion to dismiss. Conclusion. HHSC have raised immunity from suit in their motion to dismiss Coyote's original complaint. Pursuant to Federal Rules of Civil Procedure 12B1 and 12B6, and Coyote's suit is barred by jurisdictional doctrine, as HHSC has identified serious disadvantages with respect to the court and HHSC in proceeding with discovery, and there is no prejudice with Coyote's case. HHSC respectfully asks this court to vacate the previous order, document number 2, and stay all proceedings with respect to conducting of discovery and related proceedings until HHSC motion to dismiss Coyote's Second Amendment original complaint has been ruled on by the court. So again, as you all can see, this is what they asked the court for, okay? Alright, then it was done August the 3rd, like I told y'all. So now, we're going to go to the order. Let's see what the judge say. Let's see if the judge granted the order to vacate, and let's see if also the judge granted the motion to stay. Let's go there. Okay, so now as you all can see, what I have on the screen before you all is the order to the motion, or the order to answering the motion that HHSC entered into the court on August the 3rd, 2018. So we're going to find out, did the court grant the order, or did the court grant the motion, or did the court deny the motion? We're going to go over the whole motion to find out what has taken place and what is going on, okay? But as you all can see, like I told y'all and I showed y'all at the beginning of the video, that last motion was filed on August the 3rd, 2018. This one was filed on August the 6th, 2018, as you all can see that's highlighted on the screen. Okay, it's the same court in the United States District Court for the Southern District of Texas, Houston Division. Same court, same plaintiff, Coyote, same defendants, Family Law Center, Health and Human Services, Marquisha Lee, Shirley Lumen, Bridget Nally. Everything's still the same. As you all can see, the first thing that pops up, order granting defendant HHSC's opposed motion to stay scheduling conference, joint case management plan, and discovery. So again, they automatically granted the motion. Why? Because this court cannot move forward until they make a ruling on this 12 12B1, 12B6, which is sovereign immunity and failure to state a claim upon which relief can be granted. Okay, but let's read over it. Like I'm telling y'all, let's read over it. It say, after considering the opposed motion to stay scheduling conference, joint case management plan, and disclosure of interested parties by defendant, Texas Health and Human Services Commission, defendant, or HHSC, the court having reviewed the motion, the law, and arguments of all parties, enter the following order. It is ordered the defendant, HHSC's opposed motion to stay scheduling conference, joint case management plan, and disclosure of interested parties is granted. It is also ordered that the previous order to facilitate entry of a scheduling order under Federal Rules of Civil Procedure 16B and directing parties to begin the pretrial discovery process of Federal Rules of Civil Procedure 26 is vacated. So not only did they grant the order to stay, they also granted the motion to vacate. So everything is vacated so far. They cannot move forward. They no longer have any scheduling conferences, no more pretrial dates set up, none of that. All that's vacated. So let's continue. Let's say it again. Let's continue on. It said it is further ordered that discovery is stayed in this case until after the court rules on the defendant's HHSC's motion to dismiss the original complaint of plaintiff Julian S. Cayo, signed August 6, 2018 by the Honorable Judge Sim Lake. So again, don't take my word for it. Like I said, hey, these guys say you can do it, but we never seen it being done before because you can't do it. They bringing these courts to the wrong jurisdiction. But like I told y'all, I titled this video, Motion to Stay and 20 Days to Consent. So now that we see is we already went over the motion to stay and we went over the order of the motion to stay. Let's go to this 20 days to consent to find out what's going on with that. Let's go there. Okay, so now as you all can see, this is another order entered into the court on the same day. This order was entered on, again, August the 6th, 2018. The same day as the other order, granting the motion to vacate and also the motion to stay. They granted both of those, and once the judge granted both of those, he basically trying to now send it down to the magistrate judge. But let's read that so we can all get understanding of what's going on that's going to bring us till today. Okay? It says, again, same court, United States District Court, Southern Division of Texas. Plaintiff Cayo, defendant, Family Law Center, Texas Health and Human Services, Marquisha Lee, Shirley Loom, and Bridget Natalie, same defendants. Let's read the order. Order, pursuant to 28 U.S.C. subsection 636B1A and B, and the cause and delay reduction plan under the Civil Justice Reform Act, this case is referred to the United States Magistrate Judge Nancy K. Johnson. Okay, but let's continue. All parties are ordered to advise the court within 20 days of the entry of this order whether they will consent to the jurisdiction of Magistrate Judge Nancy K. Johnson for all purposes in this case pursuant to 28 U.S.C. subsection 636C. Okay, so now they send out an order and they all ask them, whoever wants to proceed in front of the magistrate judge, let us know. If you don't want to proceed, let us know. Okay, so Bridget Natalie and Sir Loom, they both agreed to proceed before the magistrate. Texas Health and Human Services agreed to proceed before magistrate judge. The only person who didn't agree was basically Wasil. He didn't send anything in. He didn't send a yes or no. So because he didn't send a yes or no, the judge gonna look at it two ways. The judge can say, okay, well, since he didn't respond back at all, I get into an order in, and that'll be done. Or he can still forward the order down to the magistrate judge because of his non-response. Whenever you have a non-response, especially to an order that's telling you to do something within 20 days and you don't do it, then the judge can move forward and take that as your acceptance. And because the judge took that as your acceptance, he can actually forward it down to the magistrate. Okay? But let's continue. It says, for the convenience of the parties, the clerk is ordered to forward to plaintiff and defendants, A, consent to proceed before United States Magistrate Judge Nancy K. Johnson form with each party's copy of this order. The August 17, 2018 initial pretrial and scheduling conference is counseled, signed at Houston, Texas on this 6th day of August 2018, signed again by Sim Lake, United States District Judge. Okay, so like I've been telling y'all, I'm going to keep y'all up to date with this thing. You have these guys running around telling y'all to go on these federal courts and that you can win. Pay your $400, you get in there, they make a fool out you and you lose. Not only did you waste your money paying them, you also wasted your money going into a federal court and losing. Okay? So now, this is what we're going to do. Since the day makes the 20th day, because this order was signed on August the 6th, like you can see, August the 6th, 2018. Today is now the 26th. So because today is the 26th, everybody put in what they was going to put in. The deadline for the 20 days have ran out. So when the judge make an order on this ruling right here, or when the judge come back and find out if they're going to go before the magistrate judge or they're going to stay before the district judge, I'll come back and let you all know. I'll let you know what the judge order or what the judge ruling was. And we're going to keep this thing moving. Okay? We're going to find out if these guys are about what they say they're about. That's all I'm saying. If they can't show us, then, hey, I wouldn't trust them, man. And I'm telling y'all, we just going to sit back and wait and see. I already know the outcome going to be. Matter of fact, I'm willing to put whatever up that this guy going to lose in court. Anybody want to make any I'm taking all bets, man. Anybody want to bet that I'm saying he going to lose. Anybody who believe he going to win, okay, I'm taking all bets, man. All bets. Well, I see I'm taking bets, buddy. This your client. Put up or shut up, man. Let's see if he going to win on that. You say he can go on federal court and win, so you should be the first one over here trying to bet me since this is your client. But he ain't going to put up no money. He barely want to talk about this case. He don't want to talk about none of the cases I put up already. So now, after I do this case, I'm going to also put up his other client, Kamani's federal appeal case where he filed his appeal in federal court because he already lost in the district court. I'm going to put up his appeal in federal court that he lost in 2018 as well. So I'm going to keep y'all posted on that. Like I stated before, man, I'm not here to play no games with these cats, man. I'm going to slow walk it. I see everything that's going on. I'm taking my time. And it's no rush. Because the outcome is going to be the outcome, and the outcome's already done for. So with that being said, if you need my help, hit me up in my email at y'allismagnified@gmail.com. Also, if you haven't hit the subscribe button, hit that subscribe button. If you haven't hit the notification button, hit that notification button as well, so you all can get notifications when my videos are posted. And not only that, share, like, and subscribe. And that's all I'm going to do for today. You all be blessed. It's 1 o'clock in the morning. I got to give me some rest. Shalom.